Hi folks, Denise Howell here, and up next on TWiL, we've got Firesheep. Is it legal to use it? We're going to talk about that. We're going to talk about video games and the First Amendment. Are violent video games free speech? The Ninth Circuit thinks so. What will the Supreme Court do? Net neutrality fared badly in recent elections, but location-based services are faring great. We're going to look at the legal ramifications about all of those with Ben Feuer, Ernie Svenson, and David O'Brien next here on TWiL.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is TWiL, This Week in Law with Denise Howell, episode 85, Node Your Privacy. This episode is brought to you by Squarespace.com, the fast and easy way to publish a high-quality website or blog. For a free trial and 10% off the lifetime of your new account, go to Squarespace.com and use TWiL, T-W-I-L, as your offer code. Hi, folks, and welcome to This Week in Law. I'm Denise Howell, your host. We are here with a great panel and lots to discuss about fun stuff, interesting stuff that has happened in the world of technology law this week. Joining us this week is David O'Brien from technicallylegal.org. Hi, David.
Hello, hello. It's great to be back.
Great to have you back. Looking forward to getting into all kinds of good stuff with you here in a few minutes. But first, let's introduce our other panelists. We do not have Colette Vogel, who lots of you have been clamoring for, and hopefully someday she will do a triumphant return to the show. But who we do have is a friend of Colette, an FOC, as it were, Ben Feuer, joining us from San Francisco. Hi, Ben.
Hi, Denise. How are you?
Great. Good to see you. Thanks for joining us.
My pleasure.
And making his triumphant return to the show is Ernie Svenson from New Orleans, Louisiana, and ErnieTheAttorney.net. Hi, Ernie.
Hey, how's it going? Good to be back.
Great to have you back. We've missed you. Our listeners have sorely missed you. I get 2 or 3 or 10 or 20 emails a week. I can't even keep track of them all.
Well, I've missed you guys, and it's good to be back.
All right. Well, it's great to have you. I was telling you guys offline, I'm kind of in the mood to talk about location. So let's start with that. Ernie, you've been checking into Foursquare for longer than I have. Facebook had some interesting announcements this week about its Deals platform, where, like Foursquare, it's going to be offering people enticements to use its placement services, or it's going to be letting vendors or stores, restaurants, etc., offer people enticements, so that the idea is you're going along, you find out where you are and what's in your area, and somebody out there offers you a discount, a coupon, a reason to come in off your beaten track and visit their business rather than somebody else's, which is one great reason why people might be willing to make the privacy trade-off that location services demand. And as I've been using Foursquare now for a bit, I can see lots of others. I can see where this kind of convenience and perk trade-off is enough for people to risk their privacy data, their location data being exposed in one way or another. I really, really like the way that Foursquare has handled letting people navigate their privacy settings and know what's being disclosed to whom, and tell people how to tweak their settings so that it matches up with their expectations. Their privacy stuff seems really straightforward and clear, having checked it out. And I'm just wondering, since I've got all you great legal minds on the phone or on the show with us today, on Skype with us today, what you see coming down the road from a legal standpoint about these services. There was a Pew Internet report that says about 4% of online Americans are using these services right now. And that's, maybe a small number, but I feel like we're on this precipice where this is about to really expand. So Ernie, we'll start with you. What do you see happening on the legal front with these things? Can you think of anything off the top of your head that you think we'll see in the courts or that possibly on the regulation side?
Well, the first solid prediction that I can make, having given many talks recently about social networking and things like Twitter and how it affects, jury selection, jury deliberation, what attorneys do. The first solid prediction I can make is that we're not going to be able to predict the ways that this is going to impact the law, because it's just, it depends on so many different things. I mean, one factor is going to be people's perception of whether the privacy settings are set correctly and whether there are any snafus, and there are certain to be those kind of situations. Another problem is going to occur when people don't take into account what it really means to disclose your location at a certain time. So I imagine that, there will be criminal trials where an alibi will be either confirmed or destroyed because somebody posted something on one of these sites that says that they were in a certain place, and then there will be a fight about whether that's accurate and how you get that admitted, and those sorts of things I think are going to happen. What else can happen? I'm sure we can talk about it, and other people on this podcast will be able to give us more insight than that. But that's my initial thought.
Yeah, I definitely was thinking along the lines of things that would happen in evidence in court. Like you were just saying, that there would be obviously a whole raft of hearsay issues in trying to admit this kind of evidence, and the fact that, you don't actually have to be somewhere to check in, and how do you know whether it's accurate or not. But, I guess like the hearsay rule works without taking into account technology, that if there is some real basis for thinking that a person is being truthful when they are engaging in this kind of activity, like the excited utterance rule, that, it's hard to fake an excited utterance, that maybe that kind of a principle could be applied to location services, because there is an incentive to be accurate in most instances. Now, of course, there could also be great incentives not to be accurate from time to time. So, who knows where that will go. But
the hearsay thing is interesting because, just the question of are you really where you say you are? Because I think Foursquare has fixed this problem, but I know initially you could check in even if you weren't anywhere near the location. But, from a hearsay perspective, it's a statement that you're making. So I think it would be admissible even if it wasn't accurate. I mean, I'm sure people are going to say, oh, no, I was just joking around. But that you may be joking around when you check in at a place where you really weren't. But if that's a statement, or if that's regarded as a statement for hearsay purposes, well, then that's a statement against your interest, presumably, and it would be admitted. And I guess we don't want to turn this into an evidence show, but it does, the question of whether you can check in at a place where you're not really near is probably something that all of these services will fix, because they don't want people to be able to do that, I'm sure.
Right. The other thing that seems to me will happen is that we'll either see regulatory tweaks or perhaps policy and procedure in terms of service kind of tweaks that are responding to what people actually do with these services. I'm thinking that on the regulatory privacy law side, that, as the administration and legislators all are looking at revamping our current privacy framework, they've got to be taking this into account. Let's hope they're taking this into account. And will impose some guidelines and penalties on the people with this data that really encourage them to safeguard it, because I think it's probably some of the most sensitive data, personal data, that people can provide to third parties. And also, just from making the business end of this work, if you're an employee and you're showing up at a restaurant every day to, do your waiter job, and you're checking in on Foursquare, that means that you're probably the mayor of the place, right? Or you're the person with the props to show off that you're there the most. And if businesses are trying to tie promotional commercial activities and offer incentives to people to visit, then, attaining that mayorship will probably be impossible unless businesses bar their own employees from doing that. So I could see that being something that they'll want to deal with. I could see, kind of an industrial espionage sort of problem cropping up. We used to hear about this with Twitter and blogs, that people would disclose information about where they were, not necessarily what they were doing, that still could be valuable to some competitor in their field, and could be confidential information that their business would not want to get out. Ben, what are your thoughts on any of this?
Well, I was going to say I'm just waiting for Ocean's 14, where the entire premise is based on location-based services and some con, because they really are difficult to track and to be certain that something that appears on Foursquare or somewhere actually had a person in a certain location and a certain place and at a certain time. You mentioned something about policy and legislative policy. I would be very surprised if any policymakers at this point are sophisticated enough with this really brand new technology in many ways to be including it in their policy plans. Certainly the Federal Trade Commission regulates these groups based on their privacy statements and what they promise they'll do in their on their websites. But I would agree with both of your comments. I think this is a brand new area of technology that's going to lead to all kinds of legal applications that haven't been considered. I'm sure family lawyers and divorce lawyers are salivating over the prospects of identifying when someone wasn't where they were supposed to be or was with someone else in some other location, because previously this was very difficult to do. I'm sure police are also looking forward to this information, even if not necessarily to use in prosecutions, but just for investigative purposes. So I think there are a lot of areas of law here. I think you guys are both absolutely right.
David, what happens when kids get involved in all this? Because they will. That of the all of the demographics that would find this useful and fun, of course, getting together with your friends is a huge incentive for using these things. Finding out what to do after school or at nighttime or what have you. And so I could definitely see a lot of people under 13 disclosing their location, which seems to me something that the government would be concerned about and wanting to regulate. What do you think?
Absolutely. Well, first of all, there's the Children's Online Privacy Protection Act, and that speaks directly to what you were talking about with children under the age of 13. And I think the FTC is involved in setting certain standards for websites that collect personal information from children under that age. So adding this dynamic of location-based check-ins from mobile devices, it's fascinating to me. I just don't know what's going to happen. And just to sort of echo your comments, this is an entirely new area of technology, not just of legal matters. So it's really hard to predict what's going to happen in the future. But certainly from, when we're thinking about 13-year-olds or people under the age of 13 or even people older than that, there's a lot of things that you might want to consider as a company if you're considering going into a location-based service online. Certainly some interesting implications for privacy policies and making sure that you have clearly articulated exactly what it is you're doing with people's personal information and especially their locations. I'm sure there's a lot of people out there who are really interested in getting a hold of that location-based information just because the marketing perspectives are huge.
Mm-hmm. Yeah, there was, just to hop in, there was a story a couple of weeks ago about a band of thieves, a band of real-world thieves who would follow people's, I don't know if it was Foursquare or one of the other location-based services, postings for when they were not at home, and would then rob them when they were not at home. And this sort of thing is just sort of getting started.
Right. In fact, I know. I remember seeing that. I think it was a full year ago.
It wasn't that long, yeah.
Yeah, December of last year, and the chat room will remind me what it was called, but it was alarming then and remains alarming. And I think probably, even more able to accomplish things like that now as the 4% grows and there's more and more of this data out there and more services doing it. The list of services available to do this kind of thing. I mean, there's Foursquare and Gowalla and now Facebook Places. But if you go and Google list of location services, somebody who's in that field, I forget who they are now, has done a list, and it's really, really long. So there are lots of people trying to get in on this action and distinguish themselves. And to your point, David, maybe there's a niche for someone to do a youth-oriented one that is really, really privacy conscious, that allows small groups of youngsters to connect with each other and use these services, but somehow, promises them and their parents an extra level of protection that doesn't exist out there, right now. So fascinating stuff. I am sure we'll continue to talk about it. I wasn't aware, Ernie, that locals in New Orleans continued to go to Commander's Palace until you checked in there one day. You must have been entertaining out-of-town guests.
Oh, did I check in there recently? I don't even remember checking in there. But, actually, that's one of the interesting uses for Foursquare is, and I found it helpful this way, is that when you go to a city where you don't really know the terrain and you wind up someplace and you have dinner and then, years later you want to go back, you can see all the places that you've checked in. Mm-hmm. So there are a lot of benefits to this whole, to this technology, which I think outweigh most of the risks, although obviously the risks have to be discovered. But it's pretty interesting stuff.
Well, as long as we're talking about privacy, last week we touched on Firesheep and some of the legal ramifications of that. There was a fun article over at Computer World by Greg Kaiser that's in our show notes, which you can, our discussion points you can get to at delicious.com/thisweekinlaw/85. And Greg was able to interview, and maybe you know him, David, Phil Malone, who's a professor at Harvard, and he runs the cyber law clinic at the Berkman Center. So his answer was he has no idea under existing law whether using Firesheep, if you're someone who's downloaded the add-on and you're sitting in Starbucks and you're snooping around to see who's out there that you could, get into their account. He has no idea whether it would be legal or not. I mean, it certainly smacks of being illegal. I think that the developer might have a separate set of legal issues to contend with, but just the users now, there seems to be two schools of thought on this, turning on the question of what is your reasonable expectation of privacy in your particular access node, that if you are on public open Wi-Fi, that it seems like a majority of people would say, well, you can't think that any of that's private. And nevertheless, though, if you are on a social networking site, you might think that your privacy settings that you've selected there are what are actually going to govern. And so, you might be able to make some hay out of that. David, what do you think? Where do you fall on that spectrum? Legal or illegal to use Firesheep?
It's not something I would recommend doing, certainly from a Starbucks. I thought really long and hard about this, about how you might try to get somebody under a statute that was using Firesheep. And you have statutory problems just with the definitions that they use. I thought about the Computer Fraud and Abuse Act, and that really doesn't fit these circumstances. You might be able to get somebody for snooping information and then using it to log into, say, Facebook after they've captured your login and your password. But it's really an interesting way of thinking about it in terms of privacy and whether or not you might have some sort of expectation of privacy from, like you said, a node that's an open access connection at a Starbucks. And, most people that use open access nodes like that might not even be aware of some of the risks. I mean, they might think that, it's an open node, so it doesn't really matter. People can probably listen in, but there are probably even tech-savvy people that don't think that the risks are that serious. So open question is, how much of an expectation of privacy would you have then? And is that something that the courts would be interested in protecting?
Well, what do you think, Ben?
Yeah, I mean, in California, we have substantially greater privacy rights protected by statute, both criminal and civilly. So there are laws prohibiting simple access of any information that you don't have authorization to access. Someone would have to find out that you're snooping on their passwords and collecting their passwords off of these nodes, or using Firesheep to do it. But there are laws outside of the federal sphere that would come into play that I think, would raise risks for people who want to do this sort of thing.
Let's talk about the developer for a second. Ernie, if the person, and I haven't seen that much background on the developer, so I'm a bit into the dark as to whether this person has gone very public or not about what they were trying to accomplish. But should the motives of the person coming up with an application like this be relevant if they're just trying to expose a vulnerability and push services into using HTTPS and offering their users more security to close this hole? Should that, do you think, immunize someone who launched something like this?
I don't know if it should immunize them. I mean, what one's motive is for creating something like this, I guess, would be relevant depending on what they were charged with and so forth. But the other thing is not just the motive, but the method. I mean, if your motive is to expose a security flaw, I think there probably are better methods to expose it than doing it this way. So I don't know what the potential liability for the developer would be. I think this is something that it certainly raised my antenna about free Wi-Fi access points. Not that that hasn't been raised already, but it's, we're getting to the point, or we're well past the point, I guess, now, where the idea of, well, I'm just going to walk into a place and they've got free Wi-Fi and I'll just start using it. I find now that I really am cautious about that, and especially when it comes to advising other lawyers about, accessing their data, because the whole issue of cloud computing for lawyers is now becoming a big deal. And I think that lawyers just have to be a lot smarter about how they access information. I mean, everybody, not just lawyers, but especially lawyers who have to protect confidential information. So that's really the takeaway I have from this story.
Yeah, I think it's interesting, too, from the standpoint of the person offering the access. Obviously that we talked last week about how users might get upset with services like Facebook or Twitter if they weren't, closing the hole on their end by making access to their sites more secure. But for the person offering, doing the nice thing of offering their customers, or maybe the person driving by the street, if you've just left your home access point open, that there could be liability concerns to deal with there too, as there were in the downloading contexts. That if someone came along and started downloading a bunch of stuff using your access point, that you certainly were going to have some issues on your hand, or some splaining to do, as they might have said in old sitcoms. So.
And Google has some splaining to do, and I think is currently in the splaining process regarding its Street View cars and how they would capture private information over wireless networks in a similar way, right? I mean, a similar kind of information. So splaining is there's plenty of it, right?
Right. Here's a good question from the chat room. Beatmaster is asking, who owns a cookie? Is there some kind of legal ownership in a cookie? Interesting question, because obviously the data is the users, but the, I guess, metadata in the cookie that says what you've been accessing and, what that cookie unlocks might be the service providers.
Yeah, I think I take it the reason they're asking that question, and by way of background, I listened to This Week in Google recently where this was discussed. And Gina Trapani and Leo talked about how this hack occurs, and apparently the way it occurs is because if everybody is on the common access point that's open, it's not secured, then when somebody logs in, the cookie that, say, Facebook or Twitter delivers to show that that person is in session, and every time they hit a new page, they don't have to log in, that cookie is captured by this program. So I guess the question is, by capturing a cookie obviously destined for somebody else's computer, is that in itself a transgression? And it might be, because it's obviously, I mean, we began by talking about, do you have an expectation of privacy when you go into a free Wi-Fi spot? And the answer is debatable. I guess maybe it's yes or no, depending on what is reasonable now. But I'm pretty sure you have a reasonable expectation that somebody's not going to hijack information that was destined for your computer. I mean, how could you legitimately claim that you had a right to snag their cookie if that gives you access to their private information? That's number one. And number two, if you then access that private information or send out a tweet or a Facebook post using their identity, I mean, I'm pretty sure you've crossed the line.
Mm-hmm. Yeah,
I'm quite certain you've crossed the line at that point on a number of levels. And certainly in California, I think capturing a cookie that's not yours would probably violate several of the state laws here, if not federal laws.
It seems like even under the Computer Fraud and Abuse Act, you'd have some issues to contend with there. All right, well, let's stay with California for a minute here. We've had some interesting developments in the Golden State and in its courts lately. Why don't you tell us, Ben, about this drug testing case, the Kaczynski opinion we were talking about right before we started the show? What went on there, and why is it interesting?
Sure. This is a case that's been going on really since the mid-2000s. It comes out of the Balco steroids investigation, Barry Bonds and his supplements. The federal government became aware that the company that Major League Baseball uses for its drug testing had identified at least 11 people. And the government was aware of 11 specific baseball players who had tested positive for steroid abuse. The government went out and got a search warrant for this lab that did this testing for these 11 names. And it turned out that the information responsive to the search warrant for these 11 names was contained on a spreadsheet of 100 and some different names of baseball players who had tested positive for steroids. Once the government got its hands on this spreadsheet, it then sought additional warrants for the records for the other 109 or so names that were on the list, or I guess 99 or so names that were on the list, essentially seeking the information on these other baseball players only from the information that it had taken during its search that was outside of the 11 names that it originally had a search warrant for. So the question that came up before the various courts, among a number of other questions, but the big question that came up is whether the government can use the historical plain view exception to the search warrant requirement in order to seize information on a computer where the government has to look at virtually all the information on the computer to get there. Just to take a step back. Yeah.
Just to give people some context who are non-lawyers, police officers walking by someone's house, they see large marijuana plants growing in the backyard. They don't need a warrant to go in and take a look.
That's exactly right. Or if they have a warrant for, say, a gun in your house, and they go in to get this gun, and they happen to see a large amount of marijuana on your table, they don't need a special warrant to get that marijuana because that marijuana is considered to be in their plain view.
Right.
The problem with computers is that any file or any document can be named anything at all. And the only way to be certain, from the government's perspective, that it's gone through everything on a computer to make sure whatever it's looking for it has, is to actually look at every file. So this comes up, for instance, in the child pornography context, where the government will have a warrant for pornography on someone's computer and go in and start searching for child pornography, and then they'll find some other documents that show money laundering. Now, the government only had a warrant and was only allowed to be in your computer to look for child pornography, but because you never know what's in any given file or what the extension is, they went through every single file on the computer, and now they're charging you for money laundering. This is constitutionally a problem because the Fourth Amendment requires a warrant for a specific thing in a specific place in order for the police to intrude upon your private area in order to do that. And there's a tension with computers because you can have a warrant for a specific thing, say information about terrorism, and then you're going through a computer and you find some other kind of criminal activity. And the police officer is then in a place of either having to close their eyes and ignore it, which they generally can't do, or your warrant for one specific thing on a computer has actually really turned into a warrant for anything on any of your computers. And so essentially the police could have a warrant for some small file somewhere, and that gives them a writ large to go through every electronic document you have. This is even. I was just gonna add briefly. This is even more of an issue in the world of cloud computing and data centers, because the government may have a warrant for some specific file somewhere on one of Google's data center services, but may decide that the only way it can ensure that that file wasn't misplaced or put in someone else's Google account or something like that is to go through every single file on all of Google's data servers, every email, for instance.
So where has the Ninth Circuit left this, and where might the Supreme Court take it?
Sure. So this went. This took a number of routes legally. It went to the Ninth Circuit. Must have been in late 2008, I would say. And a panel of judges found that that the search warrants the government had used to go in and get the names of the other 109 baseball players who had tested positive or allegedly tested positive for steroid abuse, those warrants were improperly obtained and threw them out. The case went en banc, which is what happens when the usual three-judge panel, about 20 times a year, a larger panel of 11 judges on the Ninth Circuit will rehear a case that a three-judge panel has already heard. The case went en banc, and it led to a remarkable opinion by Chief Judge Kaczynski, in which he essentially created a set of rules, sort of the way you would usually have rules when you have a statute that comes out of Congress, a set of rules for how the government is to go through computer searches. Now, Chief Judge Kaczynski is one of the most famous judges on the Ninth Circuit. He's certainly one of the most computer literate judges on the Ninth Circuit. He was involved in a scandal, a few years back, where he had a private server on the net that had some inappropriate content that, although one couldn't search for it, if you typed in the IP address directly, you could actually pull up this server and access this inappropriate content.
Right. It's actually kind of surprising that he might not recuse himself from this decision in light of his history there, although I guess maybe it's a bit tangential. But still, I mean, he does have some horses in this race, as it were.
Yeah, judges don't like to recuse themselves. You'll be surprised to hear, unless they really, can't do it with a straight face. And the fact that Chief Judge Kaczynski is so computer literate and so generally considered to be a privacy advocate, a libertarian, I'm not surprised he chose not to recuse himself from the case. But so he wrote an opinion. He eventually wrote the opinion of the court onto which 6 judges signed, making it a majority opinion, laying out these very specific rules. And these rules said that when there's a warrant for specific information on a computer, the government actually has to take the computer to a magistrate, and the magistrate will go through the computer and determine what sort of information is responsive and what sort of information isn't. It left open a number of questions. For instance, what does the magistrate do when the magistrate comes across illegal content not part of the warrant, on a computer that the magistrate can immediately tell is illegal, such as child pornography? What eventually happened is there was a petition filed in the Ninth Circuit. This is very unusual for a full court en banc rehearing. Usually these en banc panels, like I said, about 20 of them sit a year, and they revisit a three-judge panel's ruling. But one can petition to have the entire Ninth Circuit Court of Appeals, which I believe now is about 29 judges, active judges, hear the matter a third time. This has never happened in the history of the Ninth Circuit. And it didn't happen this time. But in response to this petition, Chief Judge Kaczynski withdrew the part of his opinion that laid out this very specific rules and regulations for how magistrates and the government should go about reviewing information that's on a computer where other information is going to be within the plain view of whoever's looking. The court eventually left it, in a way, open. The court found that these particular warrants were invalid and overbroad, but they didn't decide what the government and what agents and what other courts are supposed to do when these situations come up, and they're going to come up more and more.
Yeah, they sure are. Not just in the government arena. I could see this being an issue in civil discovery as well. Ernie and David, I want to get your take briefly on this case, but first I want to thank our sponsor, Squarespace. We couldn't do this show without them, and we really appreciate their support. Squarespace, of course, is the fast and easy way to publish a high-quality website or blog. Ernie, I was thinking before the show about the bad old days of when we started blogging and how different it is now than it was then, how we used to have our content scraped and turned into an RSS feed so that it could be syndicated out there and people could subscribe.
Our blogs are built out of log cabins.
Yes, exactly. Well, mine's not anymore because I am on Squarespace, and it's really a night and day kind of experience from what we used to know. I'm going to just highlight a few of their features. If you're into photography, they have Flickr photo display that is really, really cool. You can have a thumbnail or slideshow view of that. They've got Twitter widgets, again, something we never had back in the day, Ernie. They've got Google Maps and more. It's a really great way to have a website, and you can get 10% off the lifetime of your new account by going to squarespace.com and using the offer code TWiL. That's squarespace.com. Use the offer code TWiL, and you won't regret it. It is so flexible, wonderful, great for setting up any kind of web page that you might need for your business or personal interests. And certainly the blogging module makes it incredibly dynamic and interactive. So thank you, Squarespace, and we appreciate your support. Ernie, do you think that this drug testing case has much impact? You know, we've been through this morass of decisions up and down through the courts that pretty much leave this wide open. Where do you stand on it?
Well, there were a couple of things that I found interesting in reading this opinion, and I read it rather quickly, so I'm sure my insights are not as well developed as Ben's, who not only read it more closely, but also clerked on the Ninth Circuit. But one of the things I found interesting when I was reading through it was the affidavit in support of one of the search warrants said that, yes, that there could be some changing of names, and so they needed to do a broader search because the files that they were looking for might not be named what one would expect. But the other thing that I found interesting was a discussion about how the data on these computers that they were searching might be erased or hidden, or that there might be booby traps, which I found really strange because this information was in the hands of a legitimate organization, Comprehensive Drug Testing, that was just holding this information. Why would it be booby trapped? I mean, I could understand that in a case where somebody was leaving a company and they thought that their hard drive might be checked or something, and they wanted to conceal it. But this was a legitimate organization that would have no reason that I could think of to booby trap it. And I thought that it was strange that the affidavit would suggest that. And the court, to me, didn't really comment much on that. I expected more of a discussion about that, because it just seemed like an implausible reason. And the first reason was good enough, that there might be a changing of the file names or something like that. So why would you throw in the booby trapping thing? That I did not understand. And it just makes me more suspicious of government motives. And it's, to me, an example of how the police tend to fill these affidavits out however they think that they need to fill them out to get whatever information that they want. And in this case, looking at everything on a computer file, because it's, you can argue it's in plain view because you have to open up all the files to see what's in there. I mean, to me, that's like going into somebody's house, and instead of walking in and looking for the murder weapon and seeing marijuana laying on the counter, it's like rifling through everything in the house because you might smell marijuana, or it might be, the gun might be somewhere, there might be other guns. I mean, it just makes no sense to me. So that I found very troubling. And I also found it interesting that the court didn't really address that.
David, as Ben and Ernie have been talking about this, they've been drawing analogies between, and I have too, the real world of searches and seizures where you can see and smell things, and the world of electronically stored data. Do you think that that's appropriate? Is this a good place to depart from the real world and say things on computers just work differently?
It does work differently on computers because it's so easy to search an entire computer. There are various programs out there that will allow you to search the contents of entire files very quickly. And there's something to be said, though, that there is a difference about searching in the way that we might think of using a search engine online that gives you specific results when you put in a search query versus going through every file manually and looking at all of the contents and then picking things out of it. And that's what's most important to me here, is that what the court seemed to be focused on is, and I think what people are concerned about, is that there is somebody who's going through every single file and looking at all of the contents. And it becomes more like a fishing expedition than it does, something that's a search that's being executed pursuant to a valid warrant. I did really like the idea, though, of having some sort of neutral third party that would hold the computer data and then look at it. It seems to remove the authorities from it a little bit more, and protect the data and make sure that the search is done in an appropriate manner pursuant to the warrant. But obviously that not all of the court agreed with that here, and since that opinion was withdrawn, it sort of leaves me wondering what then is the right way to do that.
Right.
Maybe the answer is that it shouldn't be a magistrate. It should be some sort of neutral third party. Maybe it's a company of some sort. There are certainly companies out there that deal in trade secrets and trade secret acquisitions and stuff where valuable IP is held by a third party and people can still do due diligence on it, but not
right. So there's our second startup idea for the show. We've got the super secure location aware network for kids, and now we've got the super secure privacy aware network for going through people's searched computer hard drives, etc. So let's get the VCs on the phone once the show's wrapped. The other thing, as long as we're talking about the Ninth Circuit, there's a Ninth Circuit, surprise, surprise, decision going up to the Supreme Court that has to do with video games and who can sell violent video games to whom. What the Ninth Circuit has done in the past, and the question before the Supreme Court, has actually found that there is a First Amendment right. There's some sort of expression involved in selling violent video games to minors. And the Ninth Circuit often comes up with theories like this that the Supreme Court doesn't care for much. So we will see how this one fares. In our Facebook commentary, which you can find before the show at facebook.com/thisweekinlaw, we've got both ends of the spectrum represented. Jason Watkins says that he hopes that the First Amendment right is preserved. He respects the First Amendment, but as a parent, Oh, I'm sorry. He actually hopes the opposite. He hopes that the Supreme Court sets this aside. As a parent, he doesn't want his child exposed to such things, so he doesn't think the First Amendment should extend that far. And then Andrew Thompson takes the other side and says it's the job of the parents, not the state, to monitor what kids can and cannot do. Ernie, where do you think this one goes?
Well, where I think it goes, result-wise, going to the Supreme Court, I have no idea. Where it should go, I also am not exactly certain. I mean, it seems to me, my personal view is that that it is in the parents' interest and it is their responsibility to monitor what their kids do. They're in the best position to do that, to decide whether they want to allow their kids to do that sort of thing or whether they want to be more restrictive. And I think legislating that sort of thing is always a recipe for disaster, just because, you know, it's not like movies where you, and I know the movie industry agreed to its own ratings to avoid this issue, but it's not like where you're going into a public place with lots of other people. This is something that happens in the home. Kids get to play these video games because their parents let them or don't supervise them sufficiently. And I just don't think that this is an area where the government should be getting involved, just because it tends to it's not a one-size-fits-all problem, I guess, is basically my point.
Ben, what do you think about the speech aspect of it?
Yeah, I mean, this is a very interesting case. The statute is very broadly written. The California law prohibits the sale of video games to minors where a reasonable person considering the game as a whole would find it appeals to a deviant or morbid interest. And the game also uses violence, against people or individuals that look like people. So one of the questions that one of the justices asked in the Supreme Court hearing, which I believe was yesterday or Wednesday, was, well, what if you're killing a Vulcan? Does that fall within the statute of maiming someone who looks like a human? So there are two very interesting legal questions that go with this as well. The first is whether violence can be regulated in the same fashion that sexual obscenity is regulated. The Supreme Court has carved out an exception to the First Amendment, a complete exception to the First Amendment for obscenity, sexual obscenity. This First Amendment does not extend to things like child pornography and other certain forms of what are essentially speech, right? Because there's some form of communication, but that are so far beyond the pale that they're not entitled to First Amendment protection. So one of the questions in this case is whether certain kinds of violence can also be so far beyond the pale to be outside of the protection of the First Amendment. I think that the Supreme Court is unlikely to find that this material is obscene and to extend the sexual obscenity to an area in which it has never been extended before. However, the second question in the case is whether there can be extra limits on speech when the speech is directed at minors or available to minors. So even though Playboy may not be obscene, that is, an adult can legally purchase a Playboy, states are permitted to have regulations prohibiting the sale of a Playboy to somebody who's under the age of 17 or 18. And that, I think, is the more likely direction the court is going to go in this case, and to allow states to have that kind of regulation. One of the sort of interesting side aspects of this case is how effectively the Software Merchants Association, who's one of the groups suing the state of California to prohibit the enforcement of this law, lobbied other states to prevent them from joining California in amicus briefs before the Supreme Court. Generally speaking, when there's a state issue that is appealing to states, an area that states may want to regulate, you may get 30, 40 states to sign on to a brief in support. Here there were only 11. Several commentators have noticed that the lobbying arm of the software manufacturers was just very effective in convincing state attorneys general not to join in with California in this case.
Interesting. Maybe it's just a sign of the recent elections mood and tendency toward smaller government. We don't want, the mood of people out there is to not have government interfering with these sorts of issues in individuals' lives right now, it seems like. So who knows? Maybe that factored in.
Absolutely.
Yeah. Speaking of which, let's talk briefly about. There are a bunch of things I just want to hit as sort of items in the news that happened this week. One obviously is the election, and as a side note to the Democratic rout in general, is the fact that all the net neutrality candidates who were out there, who had come out in favor of net neutrality and supporting regulation that would ensure it, they all lost their elections. So
yeah, every single one. 95. There were 95 people running for Congress, either the Senate or the House, who had pledged support for net neutrality. 0 obtained a seat in the next Congress. And I think that this, in many ways, is going to spell a death knell to a certain degree to the net neutrality push. People certainly didn't vote against potential representatives because they supported net neutrality. It just wasn't an issue that registered on most folks' radar, but it sure registers on the radars of some big lobbying groups.
Right. David, do you think that net neutrality is a partisan issue, and is that why we saw it on 95 of these folks get shot down, or is it just a non-issue as far as most voters are concerned?
I think it's the non-issue for most voters on the whole. I think, again, we have problems, people just general awareness of what net neutrality actually is. I think it's a confusing concept to just a lot of voters out there. But we don't really know a whole lot about these Tea Party people, first of all. We don't know where they stand on some of these issues, and it sort of remains to be seen what they think about net neutrality and how they're actually going to act once they take office. And there might be events down the line that push people who are already in the House and in the Senate to sort of take notice of some of these net neutrality issues, and that might make other pushes for legislation, and that might end up being the force that affects some kind of change in the future.
Right. So did you guys all get your Google Buzz privacy settlement email?
Definitely.
Yes. So that has settled for $8.5 million, but unlike other class action settlements, none of that goes to the users. It's going to fund privacy initiatives, which is probably a good thing. I said this before on the show, and I still think 8.5 million is just a drop in the bucket to someone like Google. It's sort of more, a wrist slap for them to settle this kind of claim for this much money when it involved so many users. Other people might disagree with me on that and think it's actually a pretty big number. What do you think, Ernie?
It's a small number. And I don't think it's very significant. I think the most significant thing was the shame that Google suffered after that whole fiasco happened.
Right.
That and the fact that Buzz doesn't seem to really be catching on.
Right. Well, as something else that's a undeniably big number for the third time in a row is what happened to Jamie Thomas in her third trial, this time only on the damages issues, which is actually, now correct me if I've got all my trials mixed up, but I thought it was she was awarded, or she was hit with 1.95 million, close to 2 million in her last trial, but here it's 1.5, so they didn't quite hit her as hard, but still $64,000 per instance of infringement. That's already been knocked down. That's the jury award. And what happened last time was the trial judge came in and said, no, there's no reasonable relationship between what happened here and the damages, and we're going to test this constitutional issue somehow on the constitutionality of copyright damages. But so far, we're still just bouncing around in the trial court, and we've had our third trial. David, any insights here?
I just don't know where this is all going to go. 1.5 million. Wow. I just would not have expected that the third time around. But here we are again. I think a lot of people are very curious to see if Judge Davis is going to grant another remittitor and reduce the award again, and maybe he might do that on constitutional grounds or due process grounds. That's something that has happened here in Boston with the Tenenbaum case, too, although Gertner took a different route, and she reduced that award on the basis of due process. So you do have the constitutional issues directly at play in that case, but Judge Davis seems to sort of be pandering around the issue and doesn't want to take the constitutional route. And that, that's something that's sort of mandated to most district courts, is that if there's an easy way to resolve a constitutional question without ruling on the constitutionality of it, don't do that. Take a different route and let it resolve itself on appeal. Obviously, that didn't happen in the Tenenbaum case, but we'll see what happens with this one. It's a little bit unfortunate, I think, for Jamie Thomas, who really, in terms of actual damages to the record company, it's about $24 worth if you consider that songs are available for 99 cents on iTunes, and she had infringed on 24 copyrights. And instead, she's looking at $1.5 million.
Right.
Wow.
And then the other just quick item in the news from this week, related somewhat, is that Apple has now moved to offer 90-second iTunes samples as opposed to the 30-second samples that we've grown used to on its service. And as Apple goes with these things, so go others. What I thought was interesting here, and over at CNET, our friend Greg Sandoval has posted a copy of what Apple wrote to the music labels. Dear label representative, we are pleased to let you know that we are preparing to increase the length of music previews from 30 seconds to 90 seconds. Blah, blah, blah. This is one of these classic lawyer letters that says, here's what we're going to do. If you have no objection, take no action and it'll just happen. So I found that kind of entertaining, that this was how it was broached in just this sort of mass mailing to the labels. Ernie, what do you think of this?
Well, I think it's great that they're going to have longer samples. I recently, this is, again, I'm just, offering my personal perspective. I recently started using a service called Mog, M-O-G, that you can use for like $5 a month on your computer, or if you add it on your iPhone, it's another $5. And a friend of mine turned me onto it, and I thought, there's no way I'm going to be paying $10 a month for streaming music. But actually, I found that it's great. I mean, I love it. It's fantastic. So that kind of opened my eyes to the idea that streaming music really is something that Apple's probably going to have to contend with. And I know that they bought that company Lala that used to give full, used to allow you to stream the entire song. And maybe Apple realizes that they kind of need to be pushing in that direction. And then this is the first shoe dropping where they're saying, okay, well, we'll just increase the length of the preview. But down the road, I can't see any music company that's doing significant sales not having some sort of streaming service. And again, this is just based on having finally tried it, but being a reluctant person to try it. I didn't get how this would be useful, and I'm not going to explain and put people to sleep explaining why it is. I wrote a blog post about it a while back, but it is something transformational, and you really have to try it to understand what makes it different. The main thing for me is I don't want to store music on my hard drive, especially my iPhone. I would rather be able to just stream it, when I need it.
Yep, absolutely. I agree. Pandora has just about broken me of using iTunes the way that I used to use it for music. I've got a pretty good music collection now, but I don't find myself downloading a whole lot more these days. I'm going to go now to our tip of the week and resource of the week. Our tip of the week also relates to the Ninth Circuit and something it has done. And our tip for you as fallout from a recent Ninth Circuit decision is to check your car for GPS tracking devices that may have been planted there by the government. The Ninth Circuit has recently said that it is legal for law enforcement to secretly place such devices on your car if you are a suspect without getting a warrant, even if the car is parked in a private location. So check your car, because somebody, we have a post over at Threat Level by Kim Zettner, has actually found one of these devices on their car. And the FBI apparently asked for them back, wouldn't acknowledge one way or the other whether it belonged to the agency, but you draw your own conclusions. So check your cars, folks, take them into the mechanic. And then our resource of the week, again, you can find this over in our delicious links, is from our friends over, let's see, let me find it for you, over at the FTC. They've got actually a funny little video I linked to. The video is funny not for its content, but for its brevity. There's really no reason for them to have a video on their FTC endorsement guidelines, because all they're doing, Mary Engel, the Associate Director of Bureau of Consumer Protection over there, is telling you to check out the links and the guides that they have posted. But they do have some informative guides about their endorsement guidelines if you are someone who writes a blog or does a podcast and from time to time has relationships with vendors about things that you talk about in your blog or on your show. You will want to check these out and make sure that you understand the guidelines, because they can be a bit confusing. So with that, I'm going to go around and get some final thoughts from our panelists as we wrap up the show. David, any thoughts you want to leave with people?
Not really. There was one other interesting story that popped up, and that was the DOJ had filed an amicus brief in the Myriad Genetics patent case. And this is the case that's now, I think, in the federal circuit, and it's all about patentable subject matter and isolated genetic molecules. And in this amicus brief, the DOJ takes the position, actually, that isolated genetic molecules are not patentable subject matter. And this is completely contrary to the USPTO's policies for like the last 20 years after the Supreme Court's decision in the Chakrabarty case. That was pretty interesting to see, and we'll have to see how exactly that will play out then on the appeal.
Great. Well, keep us posted on that one, and we'll have you back on the show soon so that you can bring us up to speed as there are further developments there. And in the meantime, folks can find David over at technicallylegal.org. Thanks so much for joining us.
Thanks for having me. It's great to be here again.
And please do follow David on Twitter, too. He's D_O'Brien with an E. And it's been a great pleasure to meet you, Ben. Great to have you on the show. What final thoughts do you want to leave people with, if any?
Well, it's an exciting time for privacy rights, particularly in, as they relate to technology, with the Supreme Court taking up several of these cases every year. There's an interesting case pending before the Supreme Court now about whether not NASA contractors have privacy rights in some of their private information. And, things in this area of law are really changing rapidly. So stay tuned.
All right, we will do that. And we really appreciate your insights and analysis. Folks can find Ben at FeuerEsquire.com. That's FEUEURESQ.com. And he is Feuer Esquire on Twitter. So thanks really very much for joining us today, Ben.
Thank you. Pleasure.
And Ernie, it is so great to have you back on the show. I hope we don't have such a long gap before we get to see you again. What final words of wisdom or pearls or whatever just rattling around in your brain do you want to share with our listeners and viewers?
Well, the New York Bar Association issued an ethics opinion recently, 842, addressing the question of whether lawyers could store client confidential information in the cloud, basically, and if so, what were their duties? And I found that interesting in juxtaposition to the comprehensive drug testing case, because one of the things that lawyers say when they hear, well, there might be a problem and, there's all these issues, is they say, well, let's just not use cloud storage. Let's just forget about cloud storage. And I found it interesting because Judge Kaczynski addressed that question because apparently one of the three-judge panel, or a majority of the three-judge panel, said people can avoid these hazards involving electronic storage by just not storing their data electronically. And he said, this is crazy. Your doctor or lawyer could be storing it electronically in the cloud and you wouldn't know. And you don't have control over where your data necessarily is. And then he went on to say that there are some very important benefits to storing data electronically, which I think is the reason why lawyers should weigh this against not just the perils, but also the benefits. And Judge Kaczynski, who, as Ben pointed out, is very computer savvy, said that, being able to back up the data and avoid loss by fire, ease of access from remote locations, the ability to collaborate quickly with other professionals, for example, to send an MRI for examination by cancer specialists, that basically electronic storage and transmission of data is no longer something unusual, but rather it's kind of a way of life. And I think that is something that I hope other bar associations take into consideration when they consider passing rules to govern whether lawyers can store information in the cloud.
Yeah, there's a fellow named Martin Dean that I presented with in California to the Bar Association recently, who tossed out there, I think he would agree with you that cloud services are no longer unusual, but he tossed out there the notion that people like lawyers and doctors and anyone else with confidential private information that belongs to their clients should be getting consent from their clients if they're going to do this. And so he suggested putting them in that kind of approval requirement in a retainer letter or whatever. I'm kind of worried that kind of thing would just be rubber stamped or buried in fine print and not really have much meaningful consent. But, the notion that you get someone's consent, I think, is a good one. Yep. So anyway. Yep, I agree. Yeah. Ernie, we can find you off the show at ernietheattorney.net and Ernie Attorney on Twitter. And I often do like finding you after the show.
Can I plug my other two websites?
Absolutely, please.
Digitalworkflowscle.com, which is where I talked about the ethical consideration, and then also pdfforlawyers.com, which is where I talk about how attorneys can use Acrobat and PDFs to be more efficient.
Wonderful. Thank you so much for coming back on, and hope to see you again soon.
All right. Thanks. Take care.
And with that, folks, be good out there. We'll see you next week on the next episode of This Week in Law. Take care.